We'll hear argument first in Case 13-628, Zivotofsky versus Kerry. Ms. Lewin.
Mr. Chief Justice, and may it please the Court, how an American is identified in his or her passport or U.S. consular report of birth abroad, including the place of birth designation, does not amount to formal recognition by the United States of that designated location's sovereign status. This is the principal reason why Congress's law authorizing Jerusalem-born citizens to carry passports that say they were born in Israel is a legitimate congressional exercise of Congress's power to regulate foreign commerce.
Suppose that the President and the Secretary of State put on the passport the place of birth, I've written it out, the place of birth on this Jerusalem-born citizen's passport has been listed as Israel at the holder's request. This designation is neither an acknowledgment nor a declaration by the Department of State or the President of the United States that Jerusalem is within the borders of the State of Israel. Could the President, under existing statute, put that statement on the passport?
Yes, Your Honor, they could put that statement on the passport.
What do you think if Congress then passed a law saying that statement had to come off every passport? Could Congress do that?
Yes, Justice Kagan. There's no restriction on the initial granting of recognition by the President, but by the same token, the Congress has the ability afterwards, upon deliberation, to decide if they disagree with that recognition. But in the case that Justice Kennedy suggested —
Has that ever happened?
Yes.
In the history of the United States, where Congress, after the President had declared that it was not recognizing someone, has Congress ever recognized?
Yes, Justice Sotomayor. In 1898, Congress passed a joint resolution for the recognition of the independence of the people of Cuba over the initial opposition of President McKinley, and that ended up recognizing the independence of Cuba.
You were careful to say at the outset that this is not recognition. The Court of Appeals decision, I think it was in the Judge Tatel concurrence, said that both parties urge upon us that the power of recognition is involved here, and Congress has done it. And then, of course, the Attorney General takes the opposite position, that this A, this is recognition, and B, that's why it's void. Did you change your position here, or am I just misinterpreting the way the Court of Appeals
We've provided to
discussed
the Court alternative options for resolving this issue. Our primary position, as I said at the outset, is that what is written in this statute does not amount to a formal recognition of sovereignty, because the language of the statute itself is very narrow. It begins by saying that for the narrow purposes of recording a place of birth on a passport or a consular report of birth abroad, that is what this statute provides for. It also does not state that in all circumstances you have to list Israel as the place of birth. It is merely giving the individual choice.
The provision is part of a section 214. I think you're trying to read G as though it is disassociated from the purpose that's expressed throughout 214, that is, that Jerusalem is the capital of Israel. Congress said that, and you are trying to deal with a piece of one section without regard to the thrust of the whole provision, that Congress has said we think Jerusalem is the capital of Israel.
Justice Ginsburg, that is correct. This section of the statute should be reviewed and the constitutionality of it be determined on its own. But the Court should look not at what Congress may have intended by the entire section, but rather what this section actually did. And this section, as I said, gives the individuals a choice and does not confer formal recognition. There are benefits that come.
May you say that, but you say I've heard exactly what you say, and I think that's certainly a reasonable position. You could read this and say it doesn't really say anything about recognizing anything. But the Solicitor General of the United States, after conferring with the State Department, says, since Israel's founding, every president has adhered to the position that the status of Jerusalem should not be unilaterally determined by a party, And he adds, by requiring the President to contradict his recognition position regarding Jerusalem in official communications with foreign sovereigns, the section unconstitutionally encroaches on the President's core recognition authority. So he has a different view. He thinks it is our policy not to recognize Jerusalem as the capital, which you apparently agree with, and he thinks that this does have some tendency, at least, to suggest the contrary. Now, I'm a judge. I'm not a foreign affairs expert. And when he tells me that, and they are foreign affairs experts in the State Department, how can I say that I'm right even if I agree with you, and they who are in charge of foreign affairs are wrong when they make those two statements, which certainly sound plausible,